What is the difference between real party in interest and locus standi? Locus standi is the right of appearance in a court of justice on a given question. Specifically, it is a party's personal and substantial interest in a case where he has sustained or will sustain direct injury as a result of the act being challenged and calls for more than just a generalized grievance. In private suits, standing is governed by the real parties in interest rule as contained in Section 2, Rule 3 of the 1997 Rules of Civil Procedure as amended. It provides that every action must be prosecuted or defended in the name of the real party in interest. A real party in interest is a litigant whose right or interest stands to benefit or get injured by the judgment of the case. The interest referred to must be material interest, founded upon a legal right sought to be enforced. They bring a suit because the act or omission of another has caused them to directly suffer its consequences. Simply put, a real party in interest has a cause of action based upon an existing legal right, duty, correlative. Accordingly, the real party in interest is the party who stands to be benefited or injured by the judgment in the suit, or the party entitled to the avails of the suit. Succinctly put, the plaintiff's standing is based on his own right to the relief sought. The difficulty of determining locus standi arises in public suits. In one case, the Supreme Court held that the plaintiff who asserts a public right in assailing an allegedly illegal official action does so as a representative of the general public. He may be a person who is affected no differently from any other person. He could be suing as a stranger or in the category of a citizen or taxpayer. In either case, he has to adequately show that he is entitled to seek judicial protection. In other words, he has to make out a sufficient interest in the vindication of the public order and the securing of relief as a citizen or taxpayer. Case law in most jurisdictions now allows both citizen and taxpayer standing in public actions. The distinction was first laid in Bucamp v. Silk, where it was held that the plaintiff in a taxpayer suit is in a different category from the plaintiff in a citizen suit. In the former, the plaintiff is affected by the expenditure of public funds, while in the latter, he is but mere instrument of the public concern. As held by the New York Supreme Court in People ex rel case v. Collins, in matter of mere public right, however, the people are the real parties. It is at least the right, if not the duty, of every citizen to interfere and see that a public offense be properly pursued and punished, and that a public grievance be remedied. With respect to taxpayer suits, Terre v. Jordan held that the right of a citizen and a taxpayer to maintain an action in courts to restrain the unlawful use of public funds to his injury cannot be denied. However, to prevent just about any person from seeking judicial interference in any official policy or act with which he disagreed with, and thus hinders the activities of government agencies engaged in public service, the United States Supreme Court laid down the more stringent direct injury test in Ex parte Levitt, later reaffirmed in Tilestone v. Ullman. The same court ruled that for a private individual to invoke the judicial power to determine the validity of an executive or legislative action, he must show that he has sustained a direct injury as a result of that action, and it is not sufficient that he has a general interest common to all members of the public. The Supreme Court adopted the direct injury test in our jurisdiction. In People v. Vera, it held that the person who impugns the validity of a statute must have a personal and substantial interest in the case, such that he has sustained or will sustain direct injury as a result. The Vera doctrine was upheld in a litany of cases. Notwithstanding, the court leans on the doctrine that the rule on standing is a matter of procedure, hence can be relaxed For non-traditional plaintiffs like ordinary citizens, taxpayers, and legislators, when the public interest so requires, transcendental importance, of overreaching significance to society, or of paramount public interest. It is important to note that standing, because of its constitutional and public policy underpinnings, is very different from questions relating to whether a particular plaintiff is the real party in interest or has capacity to sue. Although the requirements are directed towards ensuring that only certain parties can maintain an action, standing restrictions require a partial consideration of the merits, as well as broader policy concerns relating to the proper role of the judiciary in certain cases. Standing is a special concern in constitutional law because in some cases, suits are brought not by parties who have been personally injured by the operation of a law or by official action taken, but by concerned citizens, taxpayers, or voters who actually sue in the public interest. Hence, the question in standing is whether such parties have alleged such a personal stake in the outcome of the controversy as to assure that concrete adverseness, which sharpens the presentation of issue upon which the court so largely depends for illumination of difficult constitutional questions. On the other hand, the question as to real party in interest, you know already, is whether he is the party who would be benefited or injured by the judgment, or the party entitled to the avails of the suit.